we have had a lot of discussion here going on. I will address it in 5 minutes. But basically, the question is only 25-1 vis-a-vis 26. It is not the interplay of 25-2 with 26. It is not there. Your Lordship should not really answer that question.
So there is no statute under 25
I am grateful.
Matter of.
Yes. And that is not there. But, my lord, I have said as an alternate, I will tell you, Lordship, my lord, what I feel. Now, I have said, my lord, yeah. So, my lord, what is the interplay of the individual when he goes, my lord, to the denomination? What's the interplay? My lord, Justice Iyengar, my lord, has said clearly in the next page that if in your own house, my lord, you do what you like, but if you go, my lord, and mingle in a place of worship, my lord, of the denomination to which you belong, you will follow the rules and procedures, like Gurdwara, like, my lord, this, that, and the other. You can't go to a Gurdwara and say, how does it matter whether I wear a headscarf or no? No. You will follow those rules if you want to be a part of the mat or part, my lord, of the denomination. Follow the rules. It is akin, my lord, to a society, to a club, to bar council, to have some orderliness, my lord. Every lawyer must follow the rules of bar council. Every member of a club has to follow those rules. Every, my lord, individual, when he goes to a mat and mingles with others, he has to follow those rules. Justice Iyengar used the phrase, it is necessary, my lord, for the denomination to keep the flock together. Can't be disruptive or schematic, the phrase used by him. How do you keep the flock together? Some amount of discipline. It has to be there. That, my lord, is on the next page. That is how the individual vis-a-vis the mat, my lord, will have to be placed. In your own place, house, you do what you like. If you don't like the mat, you can form your own religion. But if you like the mat or the denomination and you want to go there, please follow those rules. And some amount of disciplining is required, just as you can be chucked out, my lord, by a bar council or by a club or by an association. Even the mat, my lord, can throw you out if you are disruptive, etc. Kindly see, my lord, the words of Justice Iyengar in the Sayyidna case on the next page. Holds that a religious denomination possesses the right of enforcing discipline for maintenance of integrity of community. In the ultimate analysis, the binding force which holds a religious community and imparts it to a unity which makes a denomination a common faith, belief, and a belief in common creed, doctrine, dogma. The power of excommunication is vested in him for purposes of enforcing discipline and keep the denomination together as an entity. So that's how, my lord, the individual will have to fall in line when you go, my lord, to a mat or to an institution or to a club or to a society. That's how the interplay is. Now we come, my lord, to item number 6. This is, my lord, which is the most troublesome. Here comes Devaru. Now, my lord, see this. Your lordship's question. Whether the rights of a religious denomination under 26 are subject to other provisions of Part 3, apart from public order, morality, health. Public order, morality, health, of course, are there. My lord, it is my submission that 26 does not admit of any other restriction except the opening, my lord, public health, morality, and public order. It does not. If you import, my lord, the restriction of 25(2)(b) into 26, as Devaru has done, go to Devaru for a minute. You are adding a restriction to the right of 26, which the Constitution did not restrict. By no process of interpretation can a restriction placed in Article A be a restriction in Article B. 26, the Constitution makers were aware when they framed 25, they framed it subject to this. But when they came to 26, they kept only the opening restrictions. Otherwise, they could have put it in 26 also. You could have said in 26, 26 subject to public health, morality, etc., and to something which was made and be made in 25(2)(b). They didn't say that. Now see one more thing. So many articles are subject to so many restrictions. Article 19, 21, you can be deprived, my lord, of your life subject to procedure established by law. Article 22, 23, they use the same phrase. Nothing in this article. Have a look at the Constitution. Yeah. Just see this, my lord. The same thing occurs in 25, till 25. Very important. So, a simple manner of construction, my lord, would be that wherever there is a restriction, it is so stated. My lord, kindly turn to 19, your lordship has seen many times. I will not read 19. After 19, my lord, kindly turn, my lord, to 21. 21 is, the restriction is procedure established by law. Then your lordship will get to 23. See, 23 too. Nothing in this article. So again, my lord, a restriction. Now 25. Nothing in this article. That is 25 too. Now turn to 26, my lord. It is conspicuously missing, which was there in 19, 21, 23, 25, conspicuously missing. It admits, my lord, only of the first phrase, subject to this, this, and this. That's all. Therefore, there is no manner, my lord, on a pure construction of clear, unambiguous words that 26 can have a restriction of any sort except, my lord, the opening line. And there is no way that you will read 25 to be as a restriction on the right of 26. That is, my lord, a simple construction. But problem is arisen, my lord, because of Devaru. My lord, in Devaru, as the Chief Justice said, my lord, Devaru was a case, my lord, where temples, my lord, in prior to independent India, in the state of Mysore, then Mysore, did not allow, my lord, the lower class people to come to the temple. So a suit was instituted under Section 92 to frame a scheme and all that. Then came the Constitution. Plaint was again amended. Question arose, my lord, whether the denomination would still have a right to stop those people who were otherwise treated as untouchables. So when Devaru, my lord, was decided, the opening, my lord, paragraph of Devaru is this interplay. And the entire judgment of Devaru is based, my lord, essentially on Article 17. It is based only on 17, which I'll show. So if it is based on 17 and throwing open the institutions, my lord, throwing open, allowing people to go in. So Devaru said that because of 17, you have to throw open. That's 25 2B. When you throw open, in some unintended manner, you are touching the rights of the denomination under 26. Because in 26, my lord, as it then stood, 50, 60 years ago, you could stop a group from coming. So Devaru said, by virtue of 17 and 25 to be, when you allow them to come in, with the guiding light being untouchability to be removed, you are actually touching upon the rights of the institution under 26. And therefore, they have held, my lord, and I say very, very broadly, and that, my lord, is not correct, to say that 26 is subject to 25 to be. Kindly now see that. That I submit is too broad and requires a correction.
Otherwise, they would have had to strike down the law. They did not strike down the law.
They said,
They said the law is applicable to that temple.
Correct.
Therefore, you have to allow everybody to enter.
Correct. But in that process, my lord, they said that 26 will be curtailed by 25 2B. That, my lord, is not correct.
Yes, you have to harmonize it.
So, my lord, the harmonization, my lord, here would mean that you are creating a restriction in a compartment of 26 which doesn't exist in the Constitution. My lord, have a look at what I have written here. Kindly come to item number 6. See, my lord, 1. The question in Devaru was posed in para 1 of Venkatramai IRJ, whether the right of a religious denomination to manage its affairs in matters of religion guaranteed under 26 is subject and can be controlled by a law. That is a conflict. By a law under 25 2B, throwing open a Hindu temple to all classes. The question was answered by stating that to remove the taboo of untouchability as per 17, it was necessary to make a law to throw open the doors. The proposition is held in Devaru that rights under 26 will be subject to laws made under 25. Namely, this is the actual finding, my lord. We must accordingly hold that 26 must be read subject to 25 to be at below page so and so of the report is too broad a proposition. That's my submission. The case had nothing to do, Lord, what the Chief Justice remarked 1 minute ago. The case had nothing to do with the issue of social reform and welfare, but related only to the interplay of 17 and the latter part of 25 to be. Special emphasis was placed on 17 relating to the taboo of untouchability. This was tied up with the latter part of 25 for granting access to general public, which was denied. The case does not deal with the first part of 25B. The case is therefore confined to its own facts, the predominant feature being untouchable. Now, my lord, these three arguments I have made, kindly look at this. Firstly, it is submitted no specific issue has been framed by this court and a projected clash between laws framed under 25 and the right of a denomination. Not what I said 2 minutes ago. Second, the restriction to be created by law based on social reform should be treated as one only on the rights of 25(1) and not transcend into 26. Lastly, if it is held that laws under 25(2)(b) can create a restriction, which I don't agree to, then the threshold should be of a very high standard, like removal of untouchability, ban on child marriage or infanticide. So these arguments are in seriatim, my lord. Won't apply? If it applies, then apply it in this case. Now, my lord, see what happened in Sayyadna. The Attorney General advances submission number 3, saying that even on the basis that civil consequences of excommunication are a matter of religion, still a measure of social reform, and the legislation would be saved. That is the legislation, my lord, which prohibited excommunication. The legislation would be saved. The legislation was challenged, my lord, in their case. Iyengar repelled. In my view, by the phrase laws providing for social welfare and reform, it was not intended to enable the legislator to reform a religion out of existence. 25(2)(a), having provided for legislation dealing with economic, financial, political, secular activities may be associated. The succeeding clause proceeds to deal with activities of religious groups, and these are also must be those associated with religion, just as the activities referred to in Article 25(2) are obviously not of essence of religion. Similarly, the saving in Article 25(b) is not to intended to cover the basic essentials of the creed of religion protected by 25(1). Thus, 26 is not an island outside the bounds of state regulation. Undoubtedly, the state can make a regulation that religious denominations, that is freedom to manage affairs only on the ground of public order, morality and health, as stated in the opening chapter. The last point, my lord, is on locus. My lord, I submit in locus, a non-adherent will have no right to challenge, my lord, a religious practice. He can do it by a suit, etc., can't be a writ petition. And I submit, my lord, the judgment of Justice Malhotra in Sabrimala on locus, which is contrary to the 4 judges, because a lawyer, my lord, who challenged it. Justice Malhotra said, no, you can't be allowed to challenge. You are, my lord, a bystander. How are you challenging this? So the second part, my lord, is this book, my lord, which I have. Only one portion I want to show, my lord. This is the critique I had written, my lord, more than a year ago. If your lordship just turn to it. My lord, the second page of that critique is about Sabrimala and Lord Ayappa. I'm not bothering lordship with that. How it was formed, who was Lord Ayappa, how it happened, etc. Kindly, my lord, leave all that. If your lordship comes to, my lord, page 261 of that article on the top, at the foot, my lord, is the PIL issue. I have mentioned, if my lord sees that.
On the issue of maintainability.
Yes, I said that there itself, that you should not allow, my lord, people to, my lord, come to the court. They are interlopers, should not become. The next part is 265, at page 265. My lord, in this, I have discussed, my lord, the issues relating to constitutional morality, that constitutional morality has no place, etc. Then, my lord, page 271 deals with essential practices. This is actually, my lord, as they say, lordship knows, Your Lordships have said don't enter a political thicket in cases. I submit don't enter into a religious thicket to decide what is essential practice. Lord, if people are debating, Lord, priests are debating, Maulvis are debating, what is or what is not an essential practice, very difficult for a court to get involved in it. And the constitution does not use the phrase essential blood. It uses religious affairs, religious this, religious that, but not without essential religious at all. And Lord, essential practice your Lordship will get at 276. All that is here. And Lord, at 279, I have said, Lord, that Justice Malhotra's dissenting view is the correct view. Then, Lord, I have given my conclusions. The last, Lord, at 281, last para, is not supposed to be cheeky, my lord. If your Lordship sees the last para, it is not supposed to be cheeky, but I have only said, my lord, that if one has shorter judgments, they are more accessible. And I have given, my lord,
Where are you reading?
there were 2 or 3 cases.
21.
The last para of that, my lord, that critique, last page.
As a general conclusion.
My lord, if I may tell you, Lordship, your Lordships are aware. If you see, my lord, judgments like Khwaja Nazir Ahmad to do a particular thing in a particular manner, or, my lord, that judgment on conspiracy, they also serve who stand in wait. One line. Still the law, my lord. Those judgments are 3 or 4 pages each. On Hindu law, Hanuman Prasad versus Musammat Babui, 3-4 cases. They're all 3-4 pages, my lord. But you still follow them.
They were all argued for 2 days only.
So, my lord, I humbly submit, my lord, I didn't want to be cheeky, but since it was an article, my lord, I wrote that.
Oh, the Privy Council.
Your Lordships.
Sir, okay, no problem. That practice also being followed now also. Now most of the lawyers, they only read live law and bar and bench only. To understand the saying, what are the issues decided. Rightly so.
That's my submission.
Yeah, please.
I'm grateful.
Thank you, sir.
I appear for the Saidna, my lords, the head of the Dawoodi Bohra community.
Your Lordship may have Mutraj tomorrow morning, my lord, you have been waiting for it.
My lords, and how we've come here is that the original judgment of your lordships in 1962 of 5 judges in the case where that issue was challenged of the Maharashtra legislation. Then in 1986, my lords, came a writ petition which challenges a decision of the Constitution Bench. In that writ petition, my lords, first the 7 judges, which we objected to, then a 5 judges bench was constituted. And that 5 judges bench, by a reference order, sent that writ petition before your lordships, holding that specially issue number 3 and 4 have a direct bearing on the findings therein, because balancing of rights under Article 21 and other provisions was not considered, and whether morality and constitutional morality overlapped.